Yes.
Here, please, your lordship. Item number 7, my lord. Can it be next week, my lord?
As prayed for by Mr. A. Barkatoke, learned counsel appearing for the petitioner, relist on such and such date. You are there in that matter.
No, I'm
You have taken consent.
My lord, the copy has been received by Miss Preeti Gogoi. I went to her room. She has not come, my lord. I'll inform her. 27 February. Much of it.
Yes.
May please your lordship. Your lordship, with a consult the other side, I beg to this item number 8. I am for the petitioner lordship. I prefer adjournment for today as a hearing counsel Mr. Anand is out of station. So we have taken the consent and we have been informed. We already informed the other side.
It is informed with consent to the others, with consent of the other side, that Mr. N. Alam, learned counsel appearing for the petitioner, is out of station, and accordingly an accommodation is sought. Prayer is allowed, released on such and such date.
Lordship, the interim is the
Your name?
SF appear.
By SR. Interim, if any. Continue, huh?
Can it be on the first week of March, Lordship?
Next.
Lordship, interim is the interim.
I've already given it.
Yes,
Next.
much obliged.
May I please, your lordship, I beg to mention item number 28. Lordship, the engaged counsel's uncle has expired earlier this morning. Due to the sudden device, he won't be able to
You have written down the entire instruction. Why?
It's my first day, sir.
Oh, it's a first day.
Yes, sir.
You're doing very good
Thank you,
for
sir.
your first year. What is your name?
My name is Alpana Sharma Bodoloi.
MS Alpana Sharma Bordoloi. On behalf of Mr.
S. Afridi.
S. Afridi, learned counsel for the applicant, has submitted that the conducting counsel, Mr. S. Afridi, due to a demise in the family of Mr. S. Afridi, the conducting counsels, the matter be listed on any other date. You have taken consent?
Yes, sir.
Consent has also been given accordingly, relist on such and such date. Yes.
Thank you, my lordship.
You are there for, you are giving consent.
Yes, I'm for the respondent numbers 1.
All right, your name.
A. Puya.
Abe does not oppose to the aforesaid. Very good.
Thank you, my
Learned
lordship.
counsel for the respondent. 1 to 14, Mr.
Yes, 1.
9, 10, 11, 12, 14. Correct?
14.
Yes.
Item number 41. More date letter lage.
আচ্ছা আপনি petitioner in person আছে
Sir.
হয় ঠিক আছে আপনার আজি কিবা অসুবিধা আছে
মোৰ ল'ৰাৰ আজি বিয়া
ও আচ্ছা
ৰিসেপশন পাৰ্টি
আচ্ছা আজি বিয়া আছিল আপনি
ৰিসেপশন পাৰ্টি
ও ঠিক আছে as prayed for by Mr. Anil Kumar Burman, Mr. The petitioner in person, relist on such and such. কেতিয়া লাগে আপোনাক?
এক মাহ পিছত দিলে ভাল হ'ব।
Give a date on such and such date. হ'ব যোগ আপুনি সোনকালে এতিয়া।
Thank you.
13 of March. For referral to mediation, item number 1.
For respondent number 1.
But where is Mr. Das, Ms. Bharti? Shall we wait for some time? Are you agreeable?
In fact, the judgment is not against me, my lord. Against the other respondents.
Those are not on record.
They have not turned up, my lord.
I'm respondent number 1.
এবাৰ সাপ্তাহিক মাতি দিবাচোন just wait for some time
Item number 2.
এখিনি এই লিষ্টখনৰ পিছতে মাতি দিব বেছি দেৰি থাকিলে তেওঁলোকৰ এনে হেৰি হৈ যাব না item number 2 yes
My lord, I have.
Are you agreeable?
Yes, my lord. I have.
Miss Majumdar, agreeable?
Because it is their appeal, lordship, for a.
What about R2?
My lord, this is the company where the disease was used to work.
So they don't have much role to play?
as such, no, Lordship.
No, because you see why I am asking,
Uh,
because
But then, Lordship, if they want to increase, actually what happened, Lordship, the deceased himself was driving the vehicle and he was the owner of the vehicle. So the court has given 2 lakhs, which is as per the settled law. Now, if they want an enhancement on that, it is the company which has to pay because insurance
that
will
companies are two.
be R2. And because insurance company will be as per the
So Ms.
policy.
Majumdar and Mr. Shom,
My lord, Chauhan.
Sohan, Mr. Sohan, can you just wait for 5 minutes? I have called for the registrar because yesterday also few matters which I have referred. When I was signing the orders, I found that one or two of the respondents were not served.
Yes.
But if they are not served, then there is no use of sending it to the mediation
Because
center.
that day also, which I said, Lordship, it is not fit because the owner driver did not appear. If they appear, then even if it is pay and recovery, it
No,
can
so
be.
I think I'll just ask him because then these matters I do not understand why they are put in the referral list. They are
Correct.
not ready for referral yet,
Correct, correct,
isn't it?
correct.
So let me just take that clarification. Please wait, huh?
Right.
Ati Pathaisa, Saptarshik.
Proceed the serial number.
Hmm.
Item number 3.
All parties are here.
Your Lordship, I'm sorry, my lord, I could not check the response
No,
number
but what
3 and
about
4.
none has appeared. So that is
Respondent-
different, but all served.
In respect of response number 3 and 4, the service I could not ascertain, my lord, by reading the office note.
Respondent number 3 says service is complete. Only thing is that none has appeared.
Lordship.
And you are for 1 and 2?
Yes, Lordship.
4 is struck down. So service is complete.
Service.
So are you agreeable?
Lordship, we don't have any problem for mediation.
And you
The Lordship,
agreeable?
the ground is somewhat, my lord, the causal connection between death and the injury could not be
That
established.
you go try your luck once before the
Right,
mediation. It
right.
has been put in the referral list pursuant to the directions of the Supreme Court.
My
Third, Mr.
Tikolita.
T. Kalita, Learned Counsel, appearing for the appellant. Also heard Mr. J. Kalita, Learned Counsel, for the respondent numbers 1 and 2. None appeared for on behalf of respondent number 3. In view of the agreement consent between the parties, the matter is laid before the mediation center. So and so, and give a date of appearance and please give your numbers, your
Lordship,
phone numbers.
Lordship, may I pray, the matter may be referred to straightway to Lokadalat because Lordship, they will get some time to review the matter.
No, you see, it is already in this list. A referral list has been worked out pursuant to some directions. So you try one, otherwise we will
Fine.
see. Huh?
6th of March.
6th of March. Yes,
May it please your lordship. Your lordship, here parties are willing to go for mediation, your lordship.
Willing?
Yes, your
Give me
lordship.
the
At
file.
least purely on quantum of compensation.
All parties represented?
Lordship, claimants are represented and insurance company other side has, but in respect of owner and driver, they are not represented, your lordship. But if it is purely on quantum, your
So their presence may not be
May not
so
be required.
required. Okay. Heard MS
see Bothakur.
P. Borthakur, learned counsel appearing for the appellant and Mr.
Yes, okay, for respondent number
AJ Saikia, learned counsel appearing for respondent number 6 and MS.
On behalf of M. Talukdar.
MS, your name?
B. Sharma. On
B.
behalf.
P.
B. Sharma.
B. Sharma, learned counsel appearing on behalf of Mr. M. Talukdar, learned counsel for respondent number 1. Though parties have consented referring the matter to the mediation center, lay before the mediation center, baki kini did by appearance and all. Give your numbers, three of you, please give your numbers because they'll have to intimate notices.
9th of March.
Omelette.
Yes, call those two matters. Ms. Majumdar, which is yours? Heard Mr.
Sohan.
S. Chauhan, learned counsel appearing for the petitioner. Also heard MSRM Majumdar, learned counsel appearing for the respondent number
1.
1. It appears that notice in respect of respondent number 2 is not yet complete. In view of the office note dated 9/2/2026, which records as under quote unquote into Didiba. Huh? I think you'll have to take fresh steps. Let fresh steps be taken in respect of respondent number 2 by providing the. No, but it says addressee not known.
But the deceased was working, it is his actually, deceased owned this.
Fresh steps. Let fresh steps be taken. Let the matter be put in the referral list. No, let the referral list nokuba. Since the matter has been placed under the column so and so to Didiba, it is directed that the same may be this considered after completion of service. Relist after 3 weeks and then they did. 1, item 1.
Item 1.
কোন আসলে টিকেট নামটো মনত নাই
D কলিতা আছে।
এটা নাই না এটা আহি যাব পাৰ
Item 5.
Yes, Ms. Majumdar.
Lordship, this is listed for mediation, but it is not yet admitted. Admission is to be done. And in the delay petition, they have.
Not admitted and they put in the referral
Yes,
list.
yes. Because the parties are not here like that.
Item number 5 to তেওঁলোকক দেখুৱাই দিবা এইটো এডমিটে হোৱা নাই এতিয়ালৈকে so I'll admit it. Heard MS R.D. Majumdar, learned counsel appearing for the appellant. The no stay application, na?
No, we will be filing, Lordship. Because they have
The
been
present appeal is directed against the judgment and award dated 6/1/24 passed by the learned member Motor Accident Claims Tribunal number 2 Kamrup M Gauhati in MAC case number 2439 of 2017 under section 173 of the Motor Vehicles Act 1988 inter alia on the grounds that
Lordship, pay and recovery was given, whereas there is no provision, that's what we are saying, on violation of policy condition, as well as
Inter alia on the ground that the impugn award has been passed in violation of the policy conditions. Admit, no, there were steps taken are 3 weeks up so that they did job and call for TCR.
Hello. Hello.
Six.
Yes. Item 4 আছে না যোনটো admission 1 আছে
May I please join?
yes
My lord, in this case, service is not complete.
not complete no
There is office note dated 6/2/2026. It says, my lord, respondent number.
R1 has not received.
Yes.
Okay.
I-
Heard Mr. A.K. Gupta, learned counsel for the appellant. Though this matter has been placed under the column so-and-so, office note dated 6/2/2026, which reads as under quote unquote, records that service is yet to be complete. Let updated service report be placed on such and such date. Give a date after 3 weeks.
For admission, item number 9.
May I please, Your Lordship?
Yes, Mr.
Yes.
Varman.
Yes, Lordship. Here, the insurance company is the appellant. We have challenged the award of employees commissioner, Borpeta Lordship, where an award of rupees 17,79,369 was awarded in favor of the claimant, Lordship.
Employers company.
And here, Lordship, the main ground of our appeal rests upon the disability certificate and the validity of this disability certificate, Lordship. Against
Yes.
which this award was passed, 60% disability was assessed, Lordship. Lordship, I'm very much sorry, Lordship, I couldn't annex the disability certificate in question.
So substantial question of law has
Yes,
to be.
yes, Lordship.
It has to be there.
Yes, there, it has to be formulated, and there is a definite substantial question of law. Thing is that, Lordship, the disability certificate in question has been issued.
Sorry.
This disability certificate, on the basis of which the award has been passed, it's not issued according to guidelines, Lordship. And this has been issued by a private hospital and by a private doctor that is a resident doctor, Lordship. And guidelines so different, speaks differently, Lordship. There are certain guidelines, and the state government is the authority who can issue a disability certificate, and there are some certain guidelines and procedure to be followed, Lordship. I can place, Lordship. First of all, I want to place that certificate, Lordship. I did not annex along with my appeal, Lordship. At the time, it was not available. Right now, I have.
This is the disability certificate.
Yes, Lordship.
That
This
is
the disability
exhibit
certificate.
11. This is the exhibit 11.
Lordship. Lordship will find this certificate has been issued by one
Consultant.
consultant, resident doctor of Nemcare Hospital. It's
Yes.
a private hospital, Lordship.
Yes.
I think in that hospital, this claimant had been treated. So, Lordship.
So what is the point?
If you go to the certificate, Lordship, there is no mention of the percentage of the disability. There is no mention whether it is a
But
permanent.
these are factual
Yes,
aspects.
actually aspect. And
The court has already gone into the factual aspect.
Lordship.
What is the substantial question of law here?
Lordship, whether it is valid or not, that is a substantial question of law.
What is valid or not? Is there any
Yes.
bar of this
Yes.
the
Yes.
private hospital
Yes, I'm coming.
certificate?
I can satisfy your Lordship.
Because the question that you have formulated is that the certificate being issued by a private doctor of a private hospital,
Yes.
whether it can be accepted as a valid disability certificate. This is the question. So where is the prohibition? Show me.
There is another one. I can.
Because your second question also, whether the doctor of name care is legally authorized to issue a
Yes.
disability
Yes,
certificate.
Lord.
Where are the
I
bar?
have some guidelines. Lord.
Yes, show me those. Yes.
I have marked, Lordship. In the guidelines of 2001, Lordship, in pair number 4.
This is 4th January 2018.
Now there is another guideline, Lordship. Later guideline,
Yes,
2018
yes,
also.
yes.
Speaks the same manner, Lordship.
Yes.
What are the procedure to be followed? What should be the board should constitute at least 3 members, Lordship. What are the criteria? What are the qualification, Lordship? Everything has been prescribed, Lordship. And if you go to the second page, Lordship, that is a specified
Alright.
format of the disability certificate. This is a Annexure B. Here,
No,
Lordship,
but this is under what guidelines?
this is been given by the Ministry of Social Justice and Empowerment, Lordship.
Now this person was working where?
No, he's a driver, Lordship.
Driver
He is a conductor. He is a
Conduct
helper,
where?
Lordship.
Where?
As a private bus, Lordship.
As a private bus?
Yes, Lordship. He's a,
Then how is this relevant to him? He is not a government employee,
no, Lordship.
and these are guidelines.
But Lordship, it should
No,
be.
you see the standard format of the certificate.
It's a
Mr.
prescribed
Burman,
Lordship.
I'm not very convinced because a doctor, practitioner doctor, has given a certificate. Why should it not be valid? For government purpose may not be, because if they have a specific guideline.
But
But this is a private.
Is there any guideline that a private hospital can issue a disability certificate?
But where
Lordship?
is a bar for a doctor to give a certificate?
That
He's the
guideline
best
say, Lordship.
person.
There is guidelines here.
Where is the bar? What does the guideline say?
Yes, Lordship.
That
Lordship,
it
I'll
give-
come to pair number 4.
Okay, it give disability certificate will be a medical board.
Yes.
You want to say this?
Yes, there should be a medical board.
Read.
Lordship, I'll coming to pair number 4.
Yes, read.
According to person with disability, equality, opportunity, protection, rights, and full participation rules, 1996. So and so by central government in exercise of power conferred under section 1 and 2 and section 73 of the persons with disability and so and so. This is an act, Lordship. Authorizes to give disability certificate will be a medical board duly considered by central and state government. The state government may consider a medical board consisting of at least 3 members, out of which at least one shall be specialist in a particular field for assessing the locomotor, visual, including so and so. So these are some types of disability. This is the guideline, Lordship. This is to be followed. And this is done by central government. There is a specified committee, Lordship. They constitute a board, and here in I can see, Lordship, in Gauhati, Lordship, there are 2 medical colleges who issue this type of certificate. There is one is GMCH and one is a MNC, Lordship. And if I go to the online also, online process, only 2 medical source, the 2 medical are authorized to issue this type of certificates, Lordship. I don't see any private hospital can issue a such type of disability certificate, because on the basis of that he can avail a number of amenities, Lordship. He can get in opportunity in employment, Lordship. He can get benefits under the special acts, Lordship. He can get concessions, Lordship. And here, Lordship, 60% has been awarded, but there is no mention whether is it total permanent disability or partial disability.
Among the 5 or 6 substantial questions that you have formulated.
Again, Lordship, that medical practitioner was not examined in the trial.
That's why I'm coming to that now.
I have a decision.
Say, now we give you A. We'll formulate A.
Lordship.
I don't think B is required, because
No,
A will cover.
But that medical practitioner doctor was not in that regard.
No, B. Your point B. I think A and B is the same.
Yes.
Isn't it?
Yes.
So even-
Regarding that disability.
Correct.
Yes.
So we say A, whether the disability certificate exhibit
Yes.
A issued by the private owner can be accepted as a valid disability certificate, whether the same was proven. This will, you see, Mr. Borman, your A will cover
B also.
C, D, because D examined, because whether it was proved in accordance with law.
Law.
Everything will come under A. And whether proper guidelines were followed, this is a factual aspect. So this will also come under A.
Lordship, correct.
I think A, we can formulate A only.
Lordship, as you please.
No, I'm asking you, because I think
But
A covers B, C, D, because you see, it has to be a substantial question
My-
of law, right? Now, whether there was any guideline or not,
My
is not a substantial question of
my
law.
grievance are two numbers of grievance. First of all, this disability certificate My
It
plea
should
is that
be
it's
the-
not valid.
Correct.
Issued by a private hospital.
Got it.
And second one that the doctor was not
Got
examined.
it. Now that entire thing is covered under A.
Lordship. Lordship.
You see, that doctor examination, non-examination is relevant to the context, whether it has been proved in accordance with the law or not. So it will be, it is already inbuilt in A. I don't think you need another question for that. And I don't think E is required. That is again factual. So, yes,
No, that
Mr.
is-
Dotton,
that
I
is
think
comment.
you will not have any right as on date because this is only for formulating substantial question of law. You will obviously have your right to. Huh? No, CPC, what we do, CPC during hearing of substantial question of law, though notice sometime is given,
Yes.
but we generally don't hear the other side.
But then,
Because today, even if I frame it at the time of hearing, if this court finds, if you point out that no substantial question of law actually is involved, we
Yes.
may dismiss the appeal
Right.
then. So today it's a very prima facie thing. It appears that some question is there, whether we don't know the answer of this question will be what.
but then
So we'll
question
frame
is,
it.
my lord, I'll just write 2 lines. The contesting of the insurance company did not lead any evidence into the contrary. The evidence adduced by the claimant, hence the evidence adduced by the claimant remains unrebutted.
Very well,
So
we will
they
see.
did not, my lord. give
That's
any
all right.
evidence.
These are factual things. Heard Mr.
PJ Burma.
PJ
Burma.
Burman, learned counsel appearing for the appellant. Also heard Mr. S. Datta, learned senior counsel assisted by MS Mushahari, learned counsel appearing for the
Respondent claimant.
respondent claimant. So notice has to go to the others, na? Claimant will be, I think,
Then another party, there's a owner also. Owner is not
so
required.
you will be one.
He'll be
R1.
1 and 2.
One and
One
two.
and two.
1 and 2, huh? This appeal arises out of judgment and order dated 2/9/2024 passed by Commissioner of Employees Commission Borpeta in EC case number 230/2023 awarding a sum of rupees 1779,369 only under appeal arising under will tate likhe diba section 30 of the Employees Compensation Act 1926 as amended up to date. Upon hearing the parties and having perused the material on record, it appears that the appeal, it appears that the appeal be that the appellant has made out a prima facie case for admission. Let the appeal be admitted on the substantial ground as whether the disability certificate I Exhibit 11 issued by the private doctor of a private hospital can be accepted as a valid disability certificate and whether the same was proved in accordance of law.
That's highly obliged.
Notice so and so extra copies koi diba and the steps steps be taken.
Owner is not required. Because not
No, but you have read him, you take a notice, you'll have to take it out. Steps be taken, call for TCR and relist on such and such date.
So far, execution party, your lordship will see that subject to the payment of 50% along with the interest.
There is a separate IA.
No.
I don't know, my lord, because
In MFA, we don't file separate IF for 50. In MFA, it is not required. And in MSc appeal, we deposit deposit. In MFA, we don't deposit actually.
In the meantime, upon payment of 50% of the awarded amount, the judgment awarded amount the judgment and order dated 2/9/2024 passed by Commissioner so and so and so and so shall remain stayed until pending adjudication will be and this will be deposited in the registry
Right.
and upon
before the commissioner also.
before the commissioner, then upon verification release it to the claimant.
Right. You know, the lordship will see that section 30 contemplates. the
Interest.
Entire amount is required to be deposited.
Section
then-
30, which part?
30 of the Employees Compensation Act 1923.
No, where does it say? Provided anything about stay is mentioned
Yes.
here.
My lord, your lordship will find.
No appeal shall run unless involved, and in case of an order other than
No appeal shall lay against any order unless a substantial question of law, then my lord.
There is no such
no appeal shall-
thing, Lordship,
Yes,
and
Yes.
should be deposited. There is no
No,
criteria, Lordship.
My lord, it is there. My lord, even this section itself says,
where?
just I'm reading.
All right. Next.
I love that. Lordship.
Mr. Burman, you please take this back.
Yes. Yes.
May it
FAO.
please- Yes,
Yes. Has the records come?
no, this
There
is.
is there very specifically.
Where?
Provided for that the no appeal by an employer under clause there shall lie unless the memorandum of appeal is accompanied by a certificate by the commissioner to the effect that the appellant has deposited with him the amount payable under the order appeal against.
That's all right. We have given him the.
Now, my lord, they may argue that there is a decision of this honorable court which has said insurance company is not required to pay.
So, just 1 second. Mr. Datta, this proviso says that no appeal by the employer clause A shall lie unless the memorandum is accompanied by a certificate. So, the entire amount has to be first deposited.
Before the
Mr. Burman,
Lordship,
have you deposited this?
I have not such, Lordship, in other customers that in other cases also, we don't deposit 100%, Lordship. We deposit the
I don't
customer.
know what sort of argument is
But,
making.
No, but
Lordship,
this
but we
proviso,
we
Mr.
we are
Datta is
depositing
right.
50%. I am not objecting because it's.
No, that's not the question. We are talking about the
Now,
statute.
but if the appeal is.
Mr. Burman,
decided
I'm
in my
sorry, but
favor,
you have to convince me on this. I cannot.
then Lordship-
I'm not.
Then also give me some other date I can.
Because
Yes.
it is very clear.
Yes,
No
so-
appeal by an employer shall lie unless it's accompanied by a certificate.
What it is mandatory, why?
তুমি তাতে এইটো ওপৰখিনি গোটেই কাটি দিবা and নামকেইটা দিবা নহয় it appears that the appeal is not accompanied by a certificate by the commissioner to the effect that the appellant has deposited with him the amount payable under the order appealed against. Mr. Burman seeks a short accommodation to clarify the aforesaid position of law. Relist, when do you want it?
After 2 weeks.
After 2 weeks at the diba Rupak, after 2 weeks.
Public.
May it please your lordship? Lordship, as per order dated, is not dated 8/1/26, Passenger Senior Division Dubri has requested to transmit the TCR, but till now no TCR has been received. Lordship.
Our records have not received till now. Okay, we'll send a reminder then. Heard MS T. Bora, Learned Counsel for the petitioner. Appellant. Appellant and Mr. S.A. Bakhtiar, Learned Counsel for all the respondents. Records have not yet been received as called for. Issue reminder, relist after so and so.
Lordship, can it be after 24th of March because there is an occasion Eid is there also. Occasion of Eid is there.
Okay.
March of it.
Okay.
Item 11.
Yes, Mr. Bora.
My please, your lordship. My lord, the petitioner challenges the order,
All the respondents are represented?
Sole response.
Yes, sole
sole
respondent.
respondent, my lord.
Yes, what is this CRP?
My lord, the
It's
increase-
under 115
Yes,
227.
yes, no.
Yes.
7, my lord. The Indian order is at page 49, my lord. The petitioner, my lord, who is the husband, my lord, he has been directed to pay a monthly maintenance of rupees 10,000 to his wife and child. The petitioner do not have any objection to pay maintenance to his child, but he has objection to pay maintenance to his wife, my lord. Because certain conditions, facts are there that, my lord, admittedly, the wife of the petitioner has illicit relationship with someone else, my lord. It is apparent on the face of the record. We file objection there in the trial court, my lord. That objection has not been taken into consideration. Then, my lord, the affidavit of assets and liabilities of Rajneesh versus Neha. We have filed the affidavit, but the respondent has not filed any affidavit. Without considering that, my lord, it has been passed, my lord.
Maintenance of 10,000.
Yes, my lord. The petitioner is working in a private garage, my lord. He is earning only 20,000 rupees per month, my lord.
Where from are you showing that?
My lord, we have filed our assets and liabilities there, my lord. It is recorded in the order also, my lord, at
20,000.
yes, my lord.
On the other hand, the OPS filed his affidavit regarding his assets and liabilities, which shows his monthly income as rupees 10,000.
20,000.
20,000.
51, page 51, my lord. But the respondent, she has not filed her affidavit, my lord. Without the affidavit, court has decided.
She has not filed.
Not filed, my lord. And my lord, Annexure 1, if your lordship sees Annexure 1, page 21.
Have you filed your affidavit
No,
of income, assets, liabilities? You have not filed.
Not, I don't have the instruction on that, lordship.
My lord,
And currently, your lordship, also there are things that those affidavits and other things on record also need to be called, your lordship, because we received a notice based on the delay condonation that was filed, your lordship. So the records from the trial court will be required for the consideration of this revision.
No, trial court records. Why do you need it? This order is very clear.
My
This
lord,
order only talks about their affidavit showing 20,000.
And
It does
yes-
not mention anything about you.
my lord,
Where is your affidavit?
it has been mentioned, my lord. Page
Hmm.
51, second paragraph, last line.
Yes.
However, the petitioner has not filed any affidavit of her assets and liabilities.
Where?
My lord, page 51.
Yes. Correct. However, the petitioner has not filed.
Yes,
Which
my lord.
part of Rajneesh says both parties have to file? Show me.
My lord. Paragraph.
Her claim before the trial family court is that he is a businessman and he can maintain her by providing 50,000.
Yes.
But the affidavit of assets which he's filed before the family court indicates that his monthly income is 20,000. Now, if that is the monthly income, by allowing him to give 10,000, you're taking almost the entire half is gone. What remains? But that is one consideration. The other thing is that what about your assets, your income? The court of the family code indicates. However, the petitioner has not filed any affidavit of her assets and liabilities. So on what basis did the family court fasten this maintenance liability upon the respondent, the petitioner? There has to be some basis, no, to come to that figure. Yes, which paragraph, Mr. Bora?
Yes, my lord, I'm fine. And one important fact is that, my lord, the respondent wife it is admitted position of fact that while the petitioner was working in Arunachal Pradesh, she has illicit relationship with some other person.
No, those things we are not
No.
going right now, Mr.
No,
Bora.
because
So by this impugned order, 10,000 per
aspect-
month and 30,000 cost of proceedings.
yeah, that aspect we wanted to bring to the notice of the learned trial court, and we filed objection.
You give me that
Yeah.
particular direction. Where
Yes,
is
ma'am.
it mentioned that both parties have to file their assets in Rajneesh? Which paragraph? Kamal?
Yes, my lord.
divorce or case निकल गया. You should have been highlighted that paragraph, Mr. Bora.
Yes, my lord. Sorry,
The whole
Actually,
case is on that.
Yes, net is slow, my lord. That's why I'm facing problem.
Mr. Das, your junior is doing well. But you can sit. So, Rajneesh, don't worry. Mr. Das, in Rajneesh, which paragraph says both parties have to file their affidavit of income? You have a copy of Rajneesh? The affidavit of disclosures of assets and liabilities annexed as so and so, so and so. It must be. It says it must be filed to enable court to make an objective assessment of the quantum of interior maintenance, which is the exact paragraph.
Yes, my lord.
The head note says it. Yes, yes.
There are some findings, madam, in the judgment. It will be under 11, Roman 11, para A.
Para 8.
A. Under Roman 11, para A.
Roman 11. Mr. Das, just mark it here.
Paragraph 120 of the judgment, my lord.
One second.
And then enclosures are there, my lord.
Seventy-two point one.
So a guideline have been framed as how the affidavit of disclosure of assets and liabilities has to be enclosed by the parties.
Yes.
Now you see, in this case, you have not done it.
Yes.
Admittedly,
Yes,
that
admittedly.
the family court order records
Yes.
that the affidavit is not there from your side. Their side affidavit is there, monthly income is 20,000. And the family court has fixed the interior maintenance at 10. But what was the basis of the, on what basis, on what premises did the,
Basis of their affidavit.
no, that cannot be. That
Because
goes
the-
against Arjuna versus Neha. Then where is the affidavit of the wife? How much is the wife? What is her income? Is she doing some work? Where is her affidavit?
Yes, her affidavit is not there, my lord.
So
but-
then on that ground itself,
Yes.
this court in 227 can interfere with this order.
Yes, but
because
all along, my lord-
because the family court has not
Yes.
followed the principles laid down in Rajneesh versus Neha.
Yes, but all along, my lord, she has been constantly.
We don't know.
maintained
We
in
don't
in
know,
her
Mr.
petition.
Das.
Yes, I've been.
We don't know all that.
Yes,
Rajneesh versus Neha mandates
yes,
that the affidavit of income liabilities of both parties should be there so as to ensure that the family court can objectively decide the issue.
yes.
Right?
Yes.
Now, where is that affidavit?
affidavit is not there.
Without that, on what basis the
But-
10,000 figure has come, which considering that he is getting only 20,000 monthly, this court finds that is an excessive amount.
But my lord, one thing is sure, my lord, but that the petitioner, my lord, has no income and
No, we
source
don't
of
know.
income. Plus, my lord, that's what she has maintained in her, my lord.
No, that we don't know. The matter is yet to
24%,
be,
my lord.
the matter is yet to be adjudicated.
Yes.
This
Plus,
is
my lord,
only
the-
interior maintenance,
plus
isn't
the
it, Mr. Das?
Minor child also is living with her, my lord.
Whatever, we don't know her income.
Yes.
His income is before us, which is 20,000 monthly.
Yes.
He's been asked to give 10,000. He's left with only 10. He also has expenses.
He works in Arunachal Pradesh in a private garage.
Whether an objective assessment has been taken or not.
And secondly, we filed one objection that has not been taken into consideration. Page 43, you have an F, my lord.
Page,
Page 43. And here also in paragraph 8, we have stated that, my lord, he has illicit relationship, extramarital affair with some other person. In that case, she is not entitled for maintenance also. Because an Annexer 1, she herself filed one FIR against that person. Annexer 1, it is on record, my lord.
which person?
Annexer 1, that FIR is there with with another person, my lord. The wife of the petitioner.
One second. This page 43 is a written objection filed by you.
Yes, in the proceeding, that has not been considered, my lord. That has not been taken into consideration.
Which paragraph you wanted me to see?
Paragraph 8, my lord. And in support of paragraph 8, your lordship may peruse Annexer 1, my lord. That is an FIR filed by the wife of the petitioner, my lord.
Where?
Annexer 1 at page 21, my lord. It has been registered, my lord. Annexer 1. My lord, type translated copy, page 21, and original at page 23, my lord.
These things are going against you, Mr. Das. But anyway, these are matters of trial. I will not get into all this right away.
Prima facie, my lord. Prima facie.
If the matter is, my lord, remanded back with a direction to the lower court, my lord, to take, my lord, the affidavit.
That's what I'm going to
Yes.
do.
Yes, my lord.
Yes.
That is exactly what I'm thinking,
Yes,
To take
proposing.
the affidavit as well as the objection filed by
And to
the.
determine it after standing.
That's what I'm thinking. Heard Mr. D.P. Bora, Learned Counsel, appearing for the petitioner. Also heard Mr. Your name, A. Mishra. Mr. A. Mishra, Learned Counsel, appearing for the respondent number,
Sole
Sole
respondent.
respondent.
sole respondent. Huh? This petition is filed under Article 227 of the Constitution of India, read with Section 115 of CPC. Actually, this read with I don't think is required, because how this 115 will not lie, because this is not a final
Yes,
disposal.
227 is sufficient. Yes.
Only
Yes,
227.
227, my lord. Yes.
227 of the Constitution of India, assailing the order dated 25/2/2025, passed in Miss J case number 41 of 2023. Srimati Manisha Ghosh versus Osim Ghosh by the learned additional district judge FTC Tejpur at Sonitpur, whereby the petitioner husband was directed to pay
Page 52, my lord.
interior maintenance of rupees 10,000 in total per month to the petitioner, to the respondent wife from the date of filing the petition until further order, and also directed to pay rupees 30,000 as cost of the proceeding. The sole contention of the primary contention of the petitioner before this court is that the learned family court, while deciding the interim maintenance, did not decided the decided the interim maintenance without the affidavit of income, liabilities, assets filed on behalf of the respondent number wife. In contrary to the law laid down by the apex court in Rajneesh versus Neha, reported in so and so, so and so. Mr. So and so further submits that despite the objection, despite the written objection being filed before the family court to the effect that the petitioner, that the respondent wife is having an illicit relationship, which is evident from the Annexure 1 FIR lodged by the respondent wife before the jurisdictional police station, the family court did not take the same into account. Stop. Mr. Mishra, so and so Mishra, on the other hand, submits that it transpires clearly from the material on record that the respondent wife is having no source of income. Correct? Is having no source of income and is residing with her minor minor daughter, and hence requires to be maintained by the husband. But Aruperus Koidiba. In Rajneesh versus Neha, the apex court has clearly held in the context of payment of interior maintenance under Section 24 of the Hindu Marriage Act so and so, that in order to make an objective assessment of the approximate amount to be awarded towards maintenance at the interim stage, it would be imperative for both parties to submit affidavits of disclosure of assets and liabilities before the court concerned. In order to bring an uniformity, the apex court framed guidelines under Article 136, read with Article 142 of the Constitution of India, which reads as under 72 to Gute to Didiba. In the present case, though the petitioner husband has filed his affidavit of disclosure of income, assets, liabilities showing 10,000 as monthly income,
20,000.
20,000 as monthly income. However, the petitioner wife has not filed any such affidavit. The order of the family court directing interim maintenance of 10,000 without the affidavit of the petitioner wife, a respondent wife, disclosing her income, assets, liabilities before the court. The order of the family court suffers from is contrary to the direction passed by the apex court. That being so, the order cannot be allowed to stand. The matter is, however, remanded back to the family court, wherein, after taking into account of the affidavits of disclosure of income, assets, liabilities of both parties, and upon due hearing of and after due hearing both parties, the learned family court shall decide the issue of interim maintenance afresh. Within how much time? Within a period of
1 month, my lord.
1 month. 1 month from the date of receipt of the certified copy of the order along is a case record, sir? Certified copy of the order. Certified copy of the order, I'll have to give a date of appearance then.
Yes, that will be.
1 month from the date of appearance, which is fixed. Give a date.
Otherwise, the case is fixed on 21st, my lord.
21st.
Yes, my lord.
From the date of appearance of both parties. It is submitted at the bar that the matter is fixed before the family court on
21st.
21
February.
so and so.
Yes.
It is parties are directed to appear before the family court on such and such date. The from so and so date or that 1 month will run from that date. This post of
Court of Additional District Judge, FTC, Sonitpur.
Can you please provide that
Fine.
detail, Mr. Das?
Additional District Judge, Sonitpur, SP. My lord.
Only one observation, the objection filed by
I've
the.
said, hear you properly. It will include everything.
Yes, my lord.
We don't need to give any direction as how should the hearing should be done. I've already recorded one of your submission about the objection.
Yes, my lord. Deeply obliged, my lord.
Highly obliged.
I will edit a little.
Yes,
Highly
my
obliged.
lord.
All right, Mr. Mishra.
Item 12.
Yes, Mr. Mohanta,
Lordship.
where are your counterparts?
Lordship, I have filed a Lordship.
The respondents are not appearing. They
Respondents are not
refuse to accept notice.
Lordship.
1 and 2.
1 and 2, Lordship.
And what about 3?
3 already service are complete.
But no one has appeared.
No one is there.
What is this matter?
Lordship, in this trial court, Lordship, I have filed a Lordship suit, this title suit, Lordship, I'm being plaintiff, wherein 3 defendants, Lordship 1 and 2, 1, 2, and 3. As per the court order, I take steps on all the respondents, and accordingly 3 appeared and written statement will be filed. But taking several steps, Lordship 1 and 2 did not appear. Then court asked me to take first step. Accordingly, I take steps. But due to my oversight, my apology, Lordship, I take steps after the date, Lordship. Court order was 26 to 24, Lordship, that you take first steps, but I take steps subsequently. Therefore, Lordship, kindly go to the strictly page number 39, Lordship.
Yes.
Perusal of the case record shows that the plaintiff has not taken step for summons upon the defendant number 1 and 2 as directed by order dated so and so. As such, this suit against the defendant number 1 and 2 is dismissed under order rule 9 rule 2 of CPC. Then, Lordship, I file petition that no, I have already taken steps and defendant number 1 had already received, and my and as per defendant number 2, I may be allowed to take first step on defendant number 2. Then, Lordship, page number 41, the order has been passed, Lordship. May I read, Lordship? The learned counsel for the plaintiff submitted that the instance case, the stage of PW and summons was served upon the defendant number 1 on so and so. The learned counsel also submitted that he has taken step for summons upon the defendant number 2 as per direction of the court or by order so and so, and therefore he paid to vacate this order dated 14/8/2024, whereby suit against the defendant number 1 and 2 was dismissed. The learned counsel also submitted that due to bona fide mistake, he had filed the instant petition after the statutory period, therefore paid to condemn the delay by petition number 22. Perusal of the case record shows that by petition number, the plaintiff petitioner paid to vacate the order dated so and so on the ground that summons upon the defendant number was served, and the plaintiff has taken steps for summons upon the defendant number 2. The said petition under order 11 rule 4 and 5 section 1 is enclosed with this so and so. Considering the grounds shown by the learned counsel, delay is condoned and petition is allowed. Record also reveals that by order dated so and so.
What happened?
Lordship, this part is important, Lordship. Record also reveals that by order dated so and so, this suit against the defendant number 1, 2, and 2 was dismissed under order 9 rule 2 of CPC on the ground that the plaintiff has not taken step as directed by order dated so and so. Perusal of the case record shows that summons upon the defendant number 1 was duly served on so and so. Thereafter, defendant number 1 was paid for adjournment on so and so to file written statement, but subsequently the defendant 1 did not file any written statement. Perusal of the case record also shows that the plaintiff has taken step for summons upon the defendant number 2, but the said steps was taken on so and so after the dismissal of the suit against the defendant number 2 by order and so and so. In view of the above petition, so and so is rejected, and the suit against the defendant number 1 shall be proceeded ex parte to the next stage. My prayer was to face step to again defendant number 2 also, Lordship. But court rejected, no, this suit will be proceeded as a dismiss against defendant number 2. So my simple prayer is, Lordship, let me allow to take first step on defendant number 2, Lordship. That was my simple prayer, Lordship, before the petition. Court corrected 1, 2 defendant was there. Court corrected 1, but on defendant number 2 was not corrected.
No, that is because for defendant number 1, you had taken the steps before.
No, actually, I have taken.
It shows that the suit against the defendant number 1 and 2 was dismissed on the ground that plaintiff has not taken steps. Perusal of the case record shows that summons upon D1 was duly served on 1/1/2024. Thereafter, D1 appeared, took adjournment, and ultimately he did not file WS. Correct? So 1 has been, you have taken steps. 1.
Right.
However, for 2, it shows that you had taken steps after the suit was dismissed.
Lordship.
Then how can now, but by filing a petition, you wanted to take fresh steps against 2.
2, Lordship. Suit was pending. Title suit was pending.
No, but it was already dismissed.
No, Lordship.
Perusal of the case record shows that the plaintiff has taken steps for summons but the steps was taken after dismissal of the suit.
Lordship, this suit is already pending. There is a stay order also, Lordship, by this court, Lordship. Suit is not dismissed, but therefore I am coming, Lordship. Suit is already pending before it.
From where are you showing suit is pending?
Suit is pending, Lordship, last order, Lordship. Deep, Lordship, fixing on 5525 for PW, prosecution witness.
I'm sorry, Mr. Monto, your facts are also very unclear. I have not understood why at the first place you had to file that petition.
Lordship.
Why did you file the petition? Because who was appearing there? That counsel have said that due to bona fide mistake, he filed the instant petition
Lordship.
after the statutory period and therefore prayed to condone delay. Filing petition 461 of 2024. Then it says petition 462, petitioner prayed to vacate the order dated 14/8/2024.
Yes, Lordship.
On the ground, now where are these orders? Where is 14/8/24?
14, Lordship, page number 39.
39.
39.
Why you wanted to vacate this?
Lordship, even if it is not vacated, Lordship, I can't take steps on defendant number 2, Lordship. It is necessary party, Lordship. Because my
Where has your right to take steps foreclosed in this order? Which part?
Lordship, by this order, Lordship, 42.
Which part?
Perusal of the case record also shows that the plaintiff has taken step for summons upon the defendant number 2, but the said steps was taken 14/11/2024 after the dismissal of the suit.
No,
Again,
where are you reading? In page
42.
Huh?
42.
No. In page 39.
39, Lordship.
How are you aggrieved by 39 order? Why you want that you want to vacate this order?
The 39, Lordship, Lordship, perusal of the case record shows that the plaintiff has not taken step for summons upon the defendant number 1 and 2 as directed by right order court dated so. As such, this suit against the defendant number 1 and 2 is dismissed. And
Yes. So
again,
now you are saying suit is not dismissed, suit is dismissed.
suit is pending. If suit is pending, Lordship dismissed, then Lordship, I can file appeal, other provision is there. But suit is pending before the trial court. Therefore, court has stayed this. This order is totally wrong, Lordship. The court had, for the first day, court has
No,
stayed this.
I think the wording is wrong.
The
It
wording is
says
wrong.
suit against the defendant number
Yes,
1
yes.
and 2 is dismissed.
Yes.
But there are other defendants also.
Three
3,
defendants.
4, and 5 is also there.
Three already WS has been filed.
Correct. So against the wording is wrong.
Wording is wrong. But again, then Lordship, one against one, Lordship. The court has corrected that you have taken steps against the one, Lordship, after this order also. No, my simple
Anyway, 3 has not appeared till now.
till now. 1 and 2 are refused. Already interim order is writing, Lordship, but
4 has been struck off.
wasn't stuck off because he has implemented as not a necessary body.
But what about 1 and 2?
In the trial court also, they are not appearing, Lordship. That is the problem. Lordship. Here also, that is the problem. Here, after receiving the notice, not appearing in the trial
No,
court.
but the problem is where do we see that they have received? It says neither AD card nor
No
unsub
answer.
notice.
Yes, sir. That is-
You take fresh steps then. You are having a stay already. Take a fresh steps because how do we know about them?
that's it. Regarding one, Lordship.
Okay, fine. Heard Mr. T. Mohantal, Learned Counsel,
D. Mohantalaj.
কি করলো আমার?
D.
Learned Counsel appearing for the petitioner, also none appears for the respondents on call. It appears from the order. It appears that on the last occasion, this court in order dated 8/12/2025 has recorded that the respondents number 1 and 2 has refused to accept the notice, and necessary affidavit in respect of the same has already been filed by the petitioner, and accordingly has accepted the notice to be completed in respect of respondent number 1 and 2. It further appears that this court was also pleased to hold service complete in respect of respondent number 3. Despite service being completed, none appears for respondent on call today. Relist on such and such date, on that date, on the next date of listing as well. If there is no representation on behalf of the respondents, the matter shall proceed in accordance with law.
Obliged.
Interim order passed early shall continue to the next date of listing.
Obliged.
Item 13.
May I please, Lordship? May I please, Lordship?
Yes.
Lordship, Mr. G. Pegu, Lordship, the engaged counsel, Lordship. He has some difficulty, Lordship, so kindly adjourn the matter for the day, Lordship.
Any objection?
Lordship, we will be filing affidavit on objection. Lordship may grant us 3 weeks or 4 weeks of time.
Okay. Heard Miss MS?
P. Rabha.
P. Rabha, learned counsel appearing for the petitioner, also heard MS?
E.G. Das for Arsha.
AG.
H.G.
H.
G. Das for
H.G. Das, learned counsel appearing on behalf of Mr.
I. Sharma.
R. Sharma, learned counsel for the respondents. MS so-and-so, learned counsel, submits that seeks a short accommodation for filing reply in the matter. Relist 3 weeks.
4 weeks.
3 weeks.
16. Item 14.
Same, I think, Mr. Pegu. Mr. Sharma?
My lord, I have not received a complete copy of the petition.
Okay. Upar J. Pegu and D.K. Sharma for for all respondents?
My lord.
For respondents. Mr. Sharma submits that a full copy of the petition has not been received by his office. MS so-and-so undertakes to furnish a full set of the petition to the office of Mr. D.K. Sharma within a period of 2 days from today. Relist after 1 week, 2 weeks. 2 weeks on such and such date.
11th of March.
You inform Mr. Pegu if you are not in the matter, huh? To give a copy to Mr. Sharma.
Item
Okay.
15.
Late is your lordship.
Yes.
Lordship, this is the MSC appeal, my lord.
First time, Mr. Kalita.
First time, my lord. Basically, on quantum, my lord, the ground is that, my lord, the deceased person was a government service, my lord, holder under the government of Assam. And there is a notification, my lord, of 2017. Under that notification, my lord, the family person should continue to receive the interest.
All right, it's a statutory appeal, I'm admitting.
My lord.
You must have already given that statutory deposit.
Yes, my lord.
Heard Mr. T. Kalita.
My lord.
Learned counsel appearing for the appellant. This appeal is being presented under section 173 of the MV Act 1988 against the judgment and order dated 18/9/2025 passed by the learned member Motor Accident Claims Tribunal Bongaigaon in MAC case number 75 of 2021. Inter alia on the ground that
My lord, the family person should, I mean, there would be no loss of financial dependency.
on what ground are you challenging?
My lord, the family persons, my lord, the family members, the claimants herein, my lord, they are still receiving the entire salary which the deceased used to receive at the time of his death, my lord. That is on record. Lordship may kindly see page number 20. There is an evidence by the government, the official.
One second.
Page number 19, my lord. Official witness was
One
examined.
second.
My lord. I'm sorry.
On the ground that despite the family members of the deceased having received the full salary, the what was given under the award?
My lord, the loss of dependency was given.
It was not properly according to you.
That is not properly computed, my lord.
However, the loss of dependency while awarding the compensation was not properly calculated. The petition determined Bilikoba, not determined. The appellant has made out a prima facie case, appeal, admit, steps to be taken within a period of 3 days from today. Yes. Call TCR. You don't I don't think any IA is there.
IA is there, my lord.
Where is the IA?
375 to 26.
Eto TCR call curricular relist koridia. Aru in the IA koba that having her porto didiba, having admitted the having already admitted the appeal during pendency of the appeal, the subject to payment of 50%, the awarded so and so shall the judgment and so shall remain stay suspended. 50%.
If lordship permits, I can place a order from the coordinate bench, my lord.
For what?
Only the conventional heads only allowed to be withdrawn, my lord.
No, 50% you deposit. Yes.
Much of.
Disposed of.
Was it timing item number 1?
They are not there, I think.
My lord.
None appears for the appellate on call. Mr. T. Kalita is present, relist after 2 weeks on a date to be fixed.
Much obliged.
Item 16. May it please your lordship. Lordship, this is an appeal, MSc appeal.
First time.
First time, my lord. It's preferred by the my lord claimant, my lord. Seeking enhancement, my lord.
Enhancement.
Yes, yes.
Okay. Admit. Your name?
M. Doctor.
M. Doctor, huh? To your person, admit and notice. Seeking enhancement of the awarded amount of rupees 1925 to 35. Or settled Pajaba judgment. Call TCR. Hello. Give a date. Yes.
Oblige.
Item 17 and 40.
17 and 43.
43 IA is there. They were not listed together. Lordship, here we are again the same lordship, violation of policy condition. All
right. Heard MS R.D. Majumdar, Learned Counsel appearing for the appellant. This appeal is presented under Section 173 of the Motor Vehicles Act 1988 against the judgment and award dated 3/11/2025 passed by the Learned Member Motor Accident Claims Tribunal number 3, Kamrup M, Gauhati in so and so. On the ground that the award has been passed in total violation of the policy conditions. Prima facie case, admit, steps to be taken, call TCR, relist on such and such date. Give me the IA.
IA 376.
In considering the upwards of the demand, upon hearing the Learned Counsel appearing for the appellant and having already admitted the accompanying appeal, subject to payment of 50% of the awarded compensation, the judgment and so pending adjudication shall remain stayed. And upon verification, it will to release it to the claimant. Yes.
Cannot be released.
To the registry.
deposit in the
With the
registry.
registry, and if the claimant gives
No,
proper.
they can file a.
Correct.
I-
No, I don't. I put it in the order only.
No,
Upon a
because-
proper application before the registry, and the registry upon proper verification can release it to the claimant.
But Lordship,
Ah.
when the release, Lordship, our High Court judgments are there when the owner has to appear, Lordship, because if the already a judgment is given for pay and recovery, suppose our appeal is dismissed also again afterwards, Lordship, still the owner, presence of the owner is necessary for release of the amount to the claimant, Lordship.
Claimant will be not the owner.
No.
Who will be the
Owner of the vehicle, Lordship. Claimant.
On the claimant? DD by to ask the format to. Yes, next.
Withdrawal, Lordship, is allowing withdrawal.
Yes, I'm allowing it.
May I please, Lordship? But by way of this second appeal, my lord, we are challenging the my lord, first appeal.
For deciding for substantial question of law.
Yes, my lord.
Where are the questions?
My lord, we said some question of substantial question of law by
Where in your appeal? Which page?
my lord. Lordship, page 10 onwards, my lord. My lord, one order is there, my lord. Order 15/12/2025. That may be perused, my lord.
Yes, which one are you pressing?
My lord, we are formulated some another sets of my lord, substantial question of law. May I produce it?
Yes. You file it by way of an affidavit. No. Okay, I'm putting it for hearing on this.
Man,
Heard Mr. S. Alam.
K. Raman,
K. Raman, learned counsel appearing for the appellant. Pursuant to the order of this court dated 15/12/2025, Mr. So-and-so places a copy of the places the following substantial questions of law amongst other preferred for consideration is in this appeal. यहाँ पर लिख दीजिए, हाँ? A to A. ठीक है? Court को भी दिया. Let the appeal be posted on such and such date for hearing on formulation of for hearing under order 41 rule 2 CPC. Give a date.
End of month. Published. Oh, August item 19.
May I speak, my lord, as per order passed by this honorable court on last occasion, my lord, we were directed to find out the proper address of the restaurant number 1 and.
Were you able to?
Still it not, my lord, so some more time may.
All right. As prayed for by Mr. N.S.
Oh, yeah,
S.R.
yes,
Barbhuya, learned counsel appearing for the appellant, released on such and such date to enable the appellant obtain the proper address of the respondents in terms of the of this court's earlier order dated 31/2026.
my lord, one more there, my lord, dear. LCR of title suit has been received, but not title appeal yet, my lord. So
Huh?
title appeals.
Reminder may be issued for calling the LCR of title.
Since TCR has not yet received, let issue reminder.
TCR of title should receive.
Or title.
Appeal is yet to be received.
Okay. It appears that though the case records of the title suit has been received, however, the case records of the appeal is yet to be received. Issue reminder accordingly.
Deeply of that.
Reminder much.
Of that.
Item 20.
Lordship, in this matter, what I am repairing for the
Fresh
respondent.
steps. Where is respondent? Petitioner. You are appearing for which sole respondent?
Respondent.
So you have already.
Lordship, in this matter, my lord, the title should already dismissed now. That's it, there is no.
Anyway, none appears for the petitioner on call. Mr.
A. Mubarak.
A.
Mubarak.
Mubarak enters appearance on behalf of the sole respondent. Service in respect of the respondent accordingly stands complete. Repost on such and such date.
21.
Lordship,
Yes.
because of this revision petition, at this stage, Lordship, because he is appearing.
Yes.
One of the respondent, he has not filed ukalatnama because he remained outside. In the
Yeah.
earlier occasion, he told that he can appear for that respondent also. This is respondent number 6.
Yes.
My lord, I am appearing on behalf of the respondent number 1, 5, and 7. And 4 and 6. Regarding 4 and 6, my lord.
What about the others?
Others struck down.
Struck off. Name of the others have been struck off. So, my lord, I have tried to contact respondent number 4 and 6, but could not contact, my lord. So that is the position, my lord. So if they want to take fresh steps.
Otherwise also they are not contesting the suit in the.
No, we
Yes,
don't
they are not
know.
contesting.
Because that is respondent number 6 is the brother of the respondent number 5. And he is appearing for respondent number 5.
You take one more fresh steps and then we will see Mr. Deka, because we don't know, you have made them parties.
Yes. We have no separate address because he now remain outside. So if he give the proper address, then I can.
Why don't you provide the
My lord,
address?
I have also tried to contact.
You don't have the address.
But in the trial court, my lord, I have appeared on behalf of respondent number 4 and 6.
So in the trial court, you have appeared for them.
Yes.
For them. But thereafter, where they have gone, I do not know, my lord.
On the last occasion, he said that he can appear for them, but for filing ukalatnama, there is a difficult. Because they are the brothers.
But you are otherwise appearing for 2 and 3.
He is appearing for 1, 5, and 7.
So now we have 1, 5, and 7. And for whom he is not being able to file wakalatnama?
4 and 6.
4 and 6.
No, for
See, the problem is it is difficult to proceed.
Yes.
Because 4 and 6, something has to be done.
Because 4 and 6.
Where are they residing?
My lord, earlier the address which is given in this petition, my lord, they are residing there.
Where?
Thereafter,
Earlier, where? And 1, 5, and 7 are brothers of 4 and 6.
yes, my lord.
So why don't you take instructions from 1, 5, and 7?
On the last date, I made a prayer before this honorable court. That
Yes.
I shall try. But when I have contacted the defendant number 1, 5, and 7, they also tried, but they have informed me that they are not able to contact them. So that is the position, my lord. But it is a fact, my lord, that in the trial court, I have appeared on behalf of respondent 4 and 6, but
Matter is still proceeding in the trial court.
Proceeding has been
trial court,
stayed.
and I filed my IO for vacating the stay order passed by this honorable court on 13/11/2024.
Where? You have vacating application where?
He has filed an application for vacating the stay order passed in this revision petition law.
In this revision petition. my lord.
Therefore, entire matter may be hard, Lordship.
Where were they last residing?
Last residing here, Lordship. Is as per his version.
Why don't you do a paper publication?
Yes, my lord.
Do a paper publication and thereafter we'll proceed. There will be some material to
Yes,
conclude.
because it, yes.
We tried.
Because it is difficult on our part to strike down them because they are
See,
contesting.
otherwise we will insist an affidavit from him.
Yes, sir.
He has to file an affidavit. Now this affidavit his client will not give.
Your Lordship have rightly pointed out.
You
Yes,
see,
sir.
Mr. Dekka, where we have to have some materials.
Yes, yes.
Where-
I have also difficulty in strike down their name because he is.
Correct. So you the last we can only do an paper publication in the last address known. The last address is the trial court wherever the
Yes.
address is.
This address is the.
So you take it in that address then.
Then Lordship.
No,
Yes, sir.
I think that would be appropriate.
Yes. Yes, ma'am.
Heard Mr. S. Dekka, Learned Counsel appearing for the petitioners. Also heard Mr.
R.C. Sancheti.
R.C. Sancheti, Learned Counsel appearing for the respondent numbers 1, 5 and 7.
Sure.
It appears that on the last occasion, upon the submission of Mr. Dekka, the
Financial respondent 2 and 3 and the performer respondent.
no, it information. Oh, no. As whether he could appear on behalf of respondent numbers 4 and 6 as well. The matter was posted today. Today, when called, Mr. Sancheti informs that despite his best efforts, he could not contact the respondent numbers 4 and 6. That being so, Mr. Dekar seeks an alternative mode of taking steps by way of paper publication, which is allowed. Let service be taken by newspaper publication of 2 newspapers, one in vernacular and one in English. Not 1, 2. And let an affidavit of service be filed before the court. And we'll post it when?
The 1 month will be required in proper publication.
After a month,
After 1 month, and interim to continue. Lordship.
interim, if any, they shall continue to the next set of paper publication within a period of 10 days from today. 10 days is sufficient.
Yes, sir. 1 English and 1 sir.
Yes, 1 vernacular, I said. You get a copy of the order.
Yes.
There has been already been admitted, my lord. Only, my lord, the IA has been pending. It's a stay application, my lord.
Second appeal.
Second appeal. Now, it's a money decree, my lord. Now, the question is whether, my lord, stay can be granted without complying with the provision as mandated.
They can be put for hearing.
Lordship, it's a money decree, order 41 rule 1, sub rule 3 says that in a money decree, Lordship, some amount has to be paid. If Lordship may take it to order 41 rule, CPC to
Your name?
H. Agarwal.
H.
Agarwal.
H.
Yes.
Yes, Mr. Agarwal.
Order 41 rule 1, Lordship.
Order 41, Rule 1. Yes.
Sub rule 3. It starts from where the appeal is against a decree.
Yes.
Where the appeal is against a decree
For payment of money.
The appellant shall within such time as the appellate court may allow deposit the amount disputed in the appeal or furnish such security in respect thereof as the court may think fit.
Yes.
Lordship, thereafter, Lordship may kindly look into order rule 5, sub rule.
Stay of by appellate
Yes,
court.
and 5.
Yes.
5. Notwithstanding.
Yes.
Notwithstanding anything contained in the foregoing sub rules where the appellant fails to make the deposit or furnish the security specified in sub rule 3 of rule 1, the
Yes.
court shall not make an order
Yes.
staying.
Here they have not done it.
Yes, they have to pay the decretal amount or the security amount also.
But they have not yet done
Not yet
anything.
done.
Because where the
staying-
appeal is against so and so, the appeal
It
shall
is- yes.
within such time. So there was no such any direction
There's no
for
play of the impin.
for
It's
deposit.
pending now. Pending, the IA is pending.
So you do not have any objection if they deposit some amount and stay is given.
Similar matter, Lordship, it has come
Yes.
on 9th.
Give
I
give me the order.
Order. No, order.
the order, I can say that.
Give it. Share it with my court master.
I also came across a decision just now, my lord. It's
The
this,
judgment-
it is not a mandatory, my lord. It
Maybe
can
there is
be.
a judgment
No,
of
no, I
the-
am giving. You'll have to
judgment of
pay.
Supreme Court also.
It's a discretion of the court.
Once, my lordship can also, in other cases also it might help.
A bare reading of the two provisions referred to herein above shows a discretion having been conferred on the appellate court to direct either deposit of the amount disputed in the appeal or to permit such security in respect thereof being furnished as the appellate court may think fit. Needless to say that the discretion is to be exercised judicially and not of a given case. Ordinarily, execution of a money decree does not amount to irreparable injury, and in the event of the appeal being allowed, the remedy of restitution is always available to the successful party. Still, the power is there, of course, a discretionary power, and is meant to be exercised in appropriate cases. The ratio in so and so applies to interim orders on challenge to a money decree. Similar views in so and so. So, and then the matter was sent back by the apex court to the High Court. We deem it appropriate to request the High Court to reconsider the interim order, bearing in mind that the challenge was to a money decree and whether a blanket stay is merited without requiring the judgment debtor to deposit a part of the money decree. The petitioner is at liberty to move an appropriate application for clarification. Yes.
There's also punishment. The opposite party approached the Supreme Court and the Supreme Court.
This is of this court.
This is of this court. In a similar matter, Lordship, the parties.
You have given this.
Okay. Yeah.
Latagar, you have given.
Latagar, yes.
You have given. You have given.
Lordship,
Out of the same transaction, my lord, two cases is
two
pending.
cases are there. And one
So
of the-
here already some order has been
Yes,
given.
in one of the cases. No, 9 to 10.
No, yes, no.
So why a similar order?
Just for a second, if a lordship comes to the line.
What is wrong in giving this order then? Same transaction?
50%, 50,000 people will be out of 150,000.
This court is inclined to dispose of this application by directing the applicants to deposit a sum of rupees 50,000 being the security before the learned executing court within a period of 2 weeks from today. On such deposit being made, the learned executing will so and so the shall be stayed. What was the decretal amount?
150,000.
1,50,000. Fair enough. And in this case,
Same, 150,000.
same. All right, 50. Or I'll make it half.
It will
So
be,
since you want to argue a little bit, so yeah.
I will leave to your lordship, my lord, but for a second, if a lordship come to my decision.
I'm giving you 50. You want to take a risk, we can hear you. But then it might increase. It is ultimately the discretion of the court.
My lord, my prayer.
Because it's a money decree.
Yes, my lord. Payment, if fail, my lord, execution proceeding will follow, my lord.
It's a decree, my lord, they'll have to execute it.
No, it says on
Either-
such deposit being made before the executing court, the impugned judgment shall be stayed.
Yes.
So if you don't make the deposit, the execution will continue.
Yes, my lord.
You
Yes,
don't
yes.
have to.
Yes, yes.
Stay of the execution.
You want execution to be stayed,
Yes.
isn't it?
Yes.
So if you pay the deposit,
It will stay.
it will stay.
Otherwise, it will. fall.
Otherwise it will
Yes.
fall.
Only if your lordship, the prayer below 50%, it might be around 25%.
Below 50% only. 1,50,000, 50.
All right, Mr. Agarwal. You don't have to become so
No, no.
over, huh?
Yes, sir.
Heard Mr. Endas, learned counsel appearing for the appellants.
Appellant.
Huh?
Appellant, one.
अच्छा, I to ध्यान. Applicants, huh?
Appellants.
No, I'm disposing the IA.
Yes, yes.
Applicants. Also heard Mr. H. Agarwal, learned counsel appearing for the respondent. The interlocutory application under Order 41, Rule 5, read with Section 151 of CPC is preferred by the applicant to stay the operation and impugn judgment and decree dated 25/6/2024 passed by the Learned Civil Judge Senior Division Tinsukia in Money Appeal number 1 of 2023. Reverse the judgment. It is pertinent that by the impugned judgment, the trial court has reversed the judgment and decree dated 23/12/2022 passed by the appellate court. No, appellate court has reversed. The learned appellate court has reversed the judgment and decree dated 23/12/2022 passed by the learned trial court in money suit number 3 of 2000. Is it 3? No, 1.
2 money.
Huh?
2.
Money suit
2 money.
2 of 2017.
Oh, my lord, 1, 1.
1.
1.
Sure.
Sure.
Money suit 1 of 2017.
Oh, no. Money appeal.
Money suit number is 2.
2.
Money appeal
Is
is
1.
Okay, no, the money suit I want.
Is 2.
2. 2.
2
of
huh?
17.
2 of 17. Mr. Das submits that the execution proceedings be stayed
Page 6, para 10, my lord.
as the appeal involves substantial question of law and there is every possibility of the appeal being allowed upon final hearing. Stop. Mr. Agarwal, learned counsel for the respondent opposite party, submits that since the execution of a money suit is sought to be stayed under the provisions of the CPC upon payment of the upon 50% of upon payment of the decretal amount or in lieu any security being deposited, he has instruction not to oppose to the prayer of stay. That is your fair submission. He further submits that the apex court in the case of Gauhati Art and Exports versus United India Insurance Company Limited and others in I number 116279 of 2024. Emphasize that High Court should bear in mind that the challenge that in challenge to money decree, a blanket stay ought not to be issued without requiring the judgment debtor to deposit a part of the money decree. Where is the other case? He further submits that in a similar, in another transaction between the same parties, right? What is this case?
Of the same transaction, one is, their allegation is one amount of loan is taken.
Okay, anyway, let me not get into this. It's having heard the submissions of the learned counsels appearing for both the contending parties and having carefully examined the materials placed on records and also having considered the case law cited at the bar, it appears that the apex court has clearly in Gauhati Art and Export Supra held that blanket interim order could not be passed in entertaining the appeal against a money decree. Full stop. Relevant paragraph of the aforesaid judgment reads as under quote unquote paragraph 6 to Poediba. Undoubtedly, the instant regular second appeal it appears that the instant regular second appeal has already been admitted for hearing and the parties have also appeared and the records has also been received. Records received and the matter is ready for hearing. Substantial question has the answer framed. It is also observed that the substantial questions of law has also been framed. Considering that considering the same, this court is inclined to dispose of this application by directing the applicants to deposit a sum of rupees 50,000 being the security before the learned executing court within a period of 2 weeks from today, being full stop. On such deposit being made before the learned executing court within a period of 2 weeks, the impugned judgment and decree dated 25/6/2024 passed by the learned civil judge senior division Tinsukia in money appeal number 1 of 2023 shall remain stayed till disposal of the current the accompanying regular second appeal. It is further provided that if the applicant fails to make deposit, the stay so granted would automatically stand vacated in view of sub rule 5 to rule 5 of order 9.
41.
Order 41. I disposed of.
My one more submission, if you lordship.
Yes,
So,
yes.
My submission is, my lord, it's not a mandatory for the appellate.
Okay. Mr. So-and-so, Agarwal Mr. So-and-so submits that the aforesaid is not a mandatory requirement in law.
Condition to deposit the money. In
The
this case,
aforesaid, edit kori dim,
this judgment also is there.
In support of the same, he relies upon the judgment of this court in
No, lifestyle equity.
Lifestyle Equity CV and others versus Amazon Technologies so-and-so reported in 2025 live log SC 974.
2 weeks.
Can we
Can it be
eta jagat koi diba? The matter discretion or likhi dima. So just remind me to edit koi. Okay.
obliged?
23.
Please, Lord. There is a delay of
374 days?
Lost.
Yes, any objection?
I have filed objection, my lord. Maybe condone with recording my objection. My lord.
What is your objection? What is your objection? You want me to read it? What is your objection? Tell me.
Lordship, 374 days. That
It's a long delay.
long delay that was not properly
Explained.
explained.
Okay. Where is your explanation?
Paragraph, my lord, 4 and 5, my lord. 3, 4 and 5.
Okay. Heard Mr. G.
Ali.
Huh?
R. Ali.
R. Ali, Learned Counsel, appearing on behalf, appearing for the applicant. Also heard Mr. H.
H.A. Ahmed for
A. Ahmed, Learned Counsel, appearing for the respondent.
respondent number 1.
Respondent number 1. By way of this application under Section 5 of the Limitation Act, the applicant seeks condonation of delay of 347 days in preferring the connected regular second appeal against the judgment and decree dated 22/9/2023 passed by the Learned Civil Judge Senior Division Nagaon, entitled Appeal number 28 of 2018, whereby the judgment and decree dated 17/7/2018 passed by the Learned Civil Judge Junior Division number 1 Nagaon, entitled suit number 29 of 2010, was affirmed. The applicant, who is aged about 70 years of age, having been suffered from various illness and undergoing medical treatment from October 2022, there occasioned the said delay in filing the appeal. Accordingly, the interlocutory application is being filed. Upon hearing the learned, it is contended on behalf of the respondent that the delay has not been properly explained. Upon hearing the learned counsels appearing for the parties and having perused the materials available on record, it appears that due to the old age and financial hardship of the applicant, and also largely because of the medical treatment he was undergoing, the said delay had arisen. The explanation appears to be bona fide and sufficient. Delay condoned, register the connected RSA, number and register the connected SA, I disposed of.
Please, Lordship, my friend is appearing for the respondent, sole respondent. It's an RSA. On the last occasion, substantial question have been framed, and in the IA, my lord, Steve was also there. And I have checked, my lord, the trial court record as well as the appellate court both
Has come.
Has
I'll fix it for hearing.
Yes, for individual court.
Okay. Heard Mr. M. Datta, Learned Counsel, appearing for the appellant. Also heard Mr. R. Fukan, Learned Counsel, appearing for the sole respondent. It is submitted at the bar that the case records of both the trial court as well as the appellate court has been received. The matter is ready for hearing. There is a stay operating. Hearing date deduct in the month of April. Relist let the matter be now listed for hearing on such and such date.
Problem. 25. Make this a lot.
I to চাই ল'বা যে যি পেন্ডিং আছে এটা কন্টিনিউ কৰাৰ কাৰণে I to dispose of it here. Yes, please.
Lord, records were called for. It is there.
Records আহিছে?
Appearing for respondent 1 to 7.
This is also ready for hearing?
Ready for the hearing.
Ready for hearing? You are Mr.
Mr. K.S. Sodial on behalf of SK.
K.S.
K.A. Sodial.
Sodial. Heard Mr. K.S. Sodial, Learned Counsel appearing for the appellant. Also heard Mr.
V.K. Borra, my lord.
So when Mr.
V.K. Borra.
V for victory.
Lordship.
V.K. Barua, Learned Counsel appearing for the sole respondent.
No,
No, my
1 to 7.
1 to 7. What about the other respondents?
Others are shown, my lord. Not received.
My lord,
8, 9,
10 are state government, my lord.
Okay.
11,
Huh?
my lord.
only 11, my lord.
So their service is not complete.
Yes, my lord. There.
Then you do what is to be done. Office note dated 7/2/2026 indicates that service in respect of respondent number 9, 10, 11, and 12 is not complete. You are appearing for 1 to
7, my lord.
it further appears that AD card has been duly received from respondent number 8. However, on call, there is no representation on behalf of respondent number 8. Be that as it may, service in respect of respondent number 8 stands complete. Repost 3 weeks, did you see what is to be done for the others? TCR আহিছে বুলি কলো নেকি? TCR পালে বুলি কৈছো। এটা দি দিবা records of trial court as well as appellate court in the meantime has been received.
Hello.
26.
May I please the lordship? In this case, notice was issued, lordship.
You are appearing for?
I'm appealing for the respondent number 1, 2, 3, and 5.
What about 4?
Lordship, in terms of last order, notice was answered, served, but it was returned.
Fresh steps to be taken by the petitioner for issuance of notice upon 4, 5, and 6
Lordship,
has not been received till date.
lordship, I'll take.
Mr. R.K. Talukdar assures that fresh steps in terms of the last earlier court's order would be taken within a period of
Be given for 5.
1 second, Miss Counsel.
In a period of.
Please follow what is going on in the court. Just because your senior have asked you to ask something doesn't mean that you will just do that and walk away from the court.
Within 2 days, my lord.
Within a period of 2 days from today. Your name?
I'm Kumari.
Miss I. Kumari, Learned Counsel, appearing on behalf of respondent numbers 1, 2, and 3, 6. What do you want?
1, 3, and 5.
1, 2, 3, and
5.
5. Oh, so 5 is complete, huh? Mr. Agarwal, Mr.
Lordship, I'll take
Talukdar,
4.
5 is complete.
Lordship, only for respondent of 4.
ওপৰত steps যদি কি বুলি লিখিছিলা? However, Miss So-and-so who has entered appearance for respondent number 1, 2, and 3 submits that she has received instructions to appear for respondent number 5 as well. You file your power for respondent number 5 and is accordingly filing power therein. Thereof hobo. Thereof. Mr. Talukdar Tapset Koidiba assures fresh steps in respect of respondent number 4 and 6 and relist after 3 weeks of date.
Item 27.
What is this IA for?
Lordship, this IA has been filed, my lord, for correction of the cost title, my lord.
Yes.
IA number 2051/2024, my lord.
Yes. Cost title of the IA.
Lordship. And same is allowed, my lord, on 16/12/2025, my lord.
Hence the prayer is allowed. Yes. Then
As the honorable court has directed to me to furnish a corrected copy, my lord.
have you done that or not?
On 6/2/2016, my lord, 26 has been filed, my lord. The same is not on record, my lord.
I'm also not using the copy, my lord.
No, I think correction has to be done how? By
Only cost title, madam, in place of 16 days, it is 132 days reflected.
But that has to be done.
Lordship, I have already filed, my lord, before the registry, my lord, on 6/2.
It's not here. What have you filed?
Corrected file, my lord.
Corrected what?
IA 205, my lord.
What do you mean by corrected IA? Amended IA?
Amended.
Mr. A. Mubarak, Learned Counsel appearing for the applicant, submits that he has filed a amended IA in terms of the amended IA in the matter. However, the same is not on record. Mr. P.K. Dekar, Learned Counsel for the sole respondent, submits that that copy of the said amendment IA is also not served upon him. Repost on such and such date. Let registry verify and place the same on record by then. Early date of hearing, Mr. Dekar?
Oh, Milord, in the light of this honorable court order, Milord, can you have a look on my IA, Milord?
When do you want? Tell me.
Milord, in the month of April, Milord, after Bihu.
All right. What is to hear? I'm allowing it unless you insist for a hearing
Yes, sir,
of the IA. You want the IA to be heard or you want the IA to be allowed?
I have to be allowed.
Allowed.
Yes.
Okay. Heard Mr. P.K. Dekar, Learned Counsel appearing for the applicant. Stop. This application is filed seeking expeditious hearing of RSA number 131 of 2024.
Milord.
It is submitted that the RSA, the accompanying RSA is ready for hearing.
Yes, sir.
Is ready for hearing, and
Yes, sir, yes, sir.
where is ready for hearing, wherein the case records have also been received. No, it is submitted that the case records from the trial court as well as the appellate court also, as well as appellate court has been received, and the matter and the appeal is ready for hearing.
Before your lordship.
I'm allowing it. You have objecting it.
Yes, your lordship.
Why?
Lordship, they had filed an objection for early the application for early hearing. Your
Yes,
lordship.
yes.
But since they are asking to cut before the queue, no specific reason.
Don't, Mr. Mishra, I'm allowing it. I'm giving them a hearing. It's a discretion of the court. Mishra, your first name was A, na? What does A stand for?
Aniket.
Aniket. A. Mishra. Ready for hearing. This court deems appropriate in the interest of justice to allow the instant application and direct hearing, listing of the regular second appeal for hearing. When do you want it? Yes. In the month of May, give a date. In the month of May, on a date to be fixed by the registry. Okay?
Yes, yes, Milord.
Or April.
After Bihu?
Yes, then May is good.
All right. 12th of May, Milord, if possible.
12th May.
Yeah.
All right. We can fix it.
Deeply obliged.
I stands disposed of.
I don't 30 and 31.
In IA, my lord, 3888. On the last occasion, my friend submitted that they have filed objection.
The written objection is not received. The office note says.
And I have also not received the copy.
We have filed it also on the date.
It says not received.
Office note dated 9.
It was filed on the 21st.
Yes, but the office
Hello,
note 9226 says it has not been received. So you file it and serve it to the other side. Do whatever you are supposed to do. Heard, Mr. Huh? J. Kalita, Learned Counsel appearing for the.
The petitioner in item number 30.
But IA is filed by you.
IA is filed by the.
IA and the applicant.
And you are for Mr. Burman?
For respect number 7 also.
So, but this order has to be filed, given in the IA.
No, my lord, there are two cases. One is the CRP. In the civil division petition, I have filed one IA.
Okay, I'm giving it in the IA because the last order is in the IA.
I'm not particular. Regarding that, I
Okay.
delay lordship.
1 second, Mr. Burman. In IA 3888, এইটো গোটেইকেইটা তিনিটা একেলগেই দেখিছে has. অনুপম একেলগে দি দিছে ইয়াতে এনেকেই দি দিবা. Heard Mr. A.K. Gupta, na? Learned counsel appearing for the applicant, also heard Mr. J. Kalita, learned counsel for the respondent insurance company. It appears that upon the submission of the learned counsel appearing for the insurance company on the last occasion, I-22/1/2026, to the effect that a written objection has been filed, which having not been tagged with the case record, the matter was posted today. Office note dated 9/2/2026 indicates that the said written objection has not been received by the section till date, and the CIS also does not show any objection having been filed till date. Further, Mr. Gupta submits that he has also not been served with a copy of the written objection. Relist on such and such date. In the meantime, Mr. J. Kalita shall do the needful in the event to enable Mr. J. Kalita to take necessary steps in this regard. You do whatever you have to do. And Mr. Burman, you are appearing in which?
31. MSc appeal lordship. Item 31. 31.
31.
Regarding this IA lordship delay, I have no objection.
31 has some delay.
Right.
That can be condoned. Give me 31.
I will not offer any objection.
Give me.
That will be admitted.
Heard Mr. J. Kalita.
Only one thing, my lord, there is office note dated 29/1/2026. It says, my lord, no AT card or unsubmitted notice of respondent number 3, 4, and 5 has arrived as yet.
Who are they?
They are also owners and their name is track of loss. They are not just formal party.
This is condonation.
Condonation.
Who is the main? Main, I think, Mr. Burman. You are the main. You are the insurance. You both are insurance. Oh, okay. Your presence is good enough for the condonation. Heard Mr. J. Kalita, Learned Counsel appearing for the applicant. Also heard Mr. A.K. Gupta, Learned Counsel appearing for the respondent stroke insurance company.
No, I'm for respondent number 1 and 2 claimants, ma'am.
Respondent claimant numbers 1 and 2, and Mr. P.J. Burman, Learned Counsel appearing for the respondent stroke insurance company.
Sure.
The instant application is filed for condoning the delay of how many days?
189 days.
189 days in filing the appeal under section 173 of the MV Act so and so, in preferring the connected MAC appeal against judgment and order dated 22/8/2023 passed by the learned member of the Motor Accident Claims Tribunal Tinsukia in MAC case number 38 of 2015. The ground of delay.
Para number 5, 6. 5, 6, and 7.
Reads as under 5, 6, and
7.
7. 5, 6, 7. Learned counsels appearing for the respondents does not seriously oppose to the prayer of condonation. Reading the aforesaid grounds of condonation, it appears that due to want of knowledge of the judgment in order and for the time taken for preferring the appeal, the aforesaid delay had occurred. The explanation appears to be bona fide and sufficient. Delay condoned. registered the connected so and so, I disposed of.
Pardon. Regarding item number 9, Lordship, I want to clarify one thing, Lordship. This is my duty to bring up
Yes, yes, yes.
bring out the truth before it's on being
Yes.
officer of the
Yes, yes.
perhaps, Lordship,
What was that act? Employers.
Employees Compensation Act
Yes,
1923.
that
Lordship.
proviso.
Yes, that provision number 3, perhaps this learned senior has misguided this honorable court because we are not the employer. Lordship. That is specific language, specific word is there. That is by employer. Lordship. And he is required to deposit that 100% the entire amount. And we are only the insurance company. Lordship. I think that is not applicable to us.
You do one thing.
Just,
You
I will definitely.
no,
advise this on
Mr.
next day.
No. You ask him to be here at 2.
Yes. And regarding that, 50,
You are not an employer.
no, I'm an insurance company. Lordship. We have nothing to do with the vehicle.
All right, then I will issue that substantial
Yes.
question of law
And
and
regarding the other fact, Lordship, that is 50% of the deposit, Lordship. Here in this act, it is not such provision of 50% deposit because 50% deposit is given in MSC cases. This is separate act, Motor Vehicles Act, and there is under statutory
but
provision
here-
of 173, Lordship.
but in here, if I
There is no provision of that's 50% deposit or 25,000, whichever. But there 173 says
no, that I understood.
and that is already in under challenge.
That I understood.
That
But
50%.
suppose here one has to stay. What is the parameters of stay?
That is up to you, Lordship.
So
But
that's a
that
discretion.
is a-
So
outside
therefore,
scope.
by an exercise of that discretion, this court can always say subject to
court has
50%.
discretionary power.
You have any
Correct.
difficulty 50%?
No, Lordship.
So you deposit 50%. What is the total award?
17 lakhs 79. He definitely will get some amount, but this by dint of this certificate, he got 60%, and that should not be there because it is not as per the provisions. And that will come in the merit Lordship in the hearing that will come, but I'm not on that right now.
So you have to pay otherwise how much right now under that impute
17
award?
lakhs 79,000.
So now 50% of that if we allow.
I have no issue because
You don't have a problem.
He will get some amount.
Correct.
So
So therefore I'm saying
Yes.
50%.
But regarding 100%, we are not.
No, I'm not giving 100%, subject to 50%.
Again, I have to apprise that 50% already under challenge in Supreme Court.
That's all right, but it is always the
Yes,
discretion of.
discretion
In the meantime, if you have anything on that, whether
Yes,
how much it should
on that.
in the in the appeals under section
Including-
30,
including.
if there are any orders of this court,
Stay there, but not decided in larger.
if any other order is there where how the stay is given, you have one copy with you. If you get,
Then Lordship, on the next date, I will apprise this on our court.
why?
Lordship, fix the date, I think.
No, I can always have it at 2 o'clock
Then at
because
2,
it makes no sense.
Yes,
You have pointed out you are not an employer.
I will inform that as.
You are not an employer, so this provisor is not
applicable
to you. You are a,
Insurance.
but are you not a?
He was under.
Let us see where
Under the employment of
Mr.
the
Barman,
owner of the vehicle.
where is the employer defined? Let us see here
Employee is the owner of the
whether
vehicle.
employer would
The
include
it's defined.
no in the Employees Compensation Act.
Yes, it is, I think, there, but have to see.
Whether
That too, Lordship.
liability of the insurance company.
This act is basically employer and employee relationship, Lordship.
No, that's right. But
We are
you are the insurance.
We have to indemnify under the insurance policy. If insurance policy is covered, we are
Is
we have to pay.
employer defined?
Employer, I think definitely there. In MPF, it is there.
Employer includes any body or persons, whether incorporated or not,
Yes.
any managing agent of an employer and the legal representative of a deceased employer, and when the service of an employee are temporary so and so,
Yes.
entered into so and so.
There is nothing about the insurance company. It's a separate relationship.
You have him at 2.
Yes, Lordship. I'll inform. Problem.
Yes. It will order to কৈ দিবা প্ৰণৱক আৰু এটা অৰ্ডাৰ দিছিলো তো সেইটো লিখি ল'বলৈ ক'ব কাটি দিছিলে যে দুটা অৰ্ডাৰ লৈলো
I don't have to.
এই এচিটো ইমান দি থৈছা যে
Early hearing special I filed.
Early hearing.
It affects, I on the consent, it is 24 March.
Yes. Hey, early hearing এটা দিছিলো নেকি? একেটা একেই কৰি দিবা ইয়াত নামকেইটা চেঞ্জ কৰি দিলে হয়। J. Ahmed and Mr. Huh?
J. Mehdi on behalf of Mr. P.K. Dega. J. Mehdi.
Your
P.K.
name.
Dega. J. Mehdi on behalf of Mr. P.K. Dega.
If you tell me so many names, I get confused. First, give me your name. J. Medhi. J. Medhi on behalf of PK Deka. And respondent, sole respondent? Sole respondent?
Yes.
Sure.
All responded.
Respondents correct. And yes, same, like everything same. In the month of
Date may be 24 March.
no,
On the
not
contract.
March. April.
April
Give
is
a date in April.
April is vacation. Long vacation is there.
No. April is not the entire month of April. This court doesn't stay closed. Yes, give a date in April. Yes, next.
Item 33.
What withdrawal you want?
Yes, Your Lordship. Opposite party filed title suit 30 of 22 for divorce in the trial court, along with filed a miss case 29 of 22 for maintenance. That being aggrieved, petitioner before Your Lordship filed CRP number 12933 of 23, along with IA 3171 of 23, Section 5 of the Limitation Act in item number 35. Kindly give me 35.
Now you have to withdraw all this.
Yes, Your Lordship. 35, 34, 35.
There has been a compromise.
Yes, Your Lordship, which is a part of a decree.
Where are those?
And decree are the also annexed. Annexed X. Thirty-four, 35. IF
So
495, item number 3.
now you want to withdraw which civil revision?
Civil revision CRP IO 1758 of 24 and
That is serial number. There is a
and
condonation.
IS Civil 495 of 24. This is item number 33.
And serial. That means there is a delay.
Delay, yes, Your Lordship kindly peruse the order.
No. Huh?
1-2-24.
Delay is condoned.
Two separate petition along with the Honorable Court by the order that
Miss Counsel, my office is not being able to give me those files. What is it? I have
IA is there, Your
delay
Lordship.
condone holne. So, pula.
Your Lordship.
1 second. So it was our delay. Yes. So now you don't want to press that condonation. You want to withdraw the condonation.
Both the IA, IS
Areta
level
IS for
6A.
দুটা আয়ে ন দুটা আয়ে for
Duta
condonation
IA.
এটা আৰু এটা আয়ে withdrawal কাৰণে আছে নেকি
Confirmation. It will withdraw the
How many applications for withdrawal have you filed? Two.
One is IA Civil 495 of 24 in IA number
No, 1 second. We will go one by one, miss. Otherwise you will have problems. If you do not have the right reference in the order, no purpose will serve. Correct. So go slow. First, I'm taking IA 316. Okay?
Yes.
IA 316. Now in IA 316, you want to withdraw IA Civil 495?
Yes,
495, IA Civil 495 to law. Lola? আর একটা civil revision আছে নি তাতে IO so and so
1758 of 24.
and what is Your prayer is only defective, I think. Civil revision petition and also civil revision. How many civil revisions have you?
There are two civil revisions.
One is 1758 paisa. It will 495 or লগত থাকা. Then have you got IO civil revision IO number 12933? What is that?
It is filing number.
And IA number 495?
CRP IO 175.
Yes.
Of
No. 12933. It is silent.
12933 is
What is that?
CRP number.
Ekita ekelege thwa. Aru 495. IA number civil 495. Etu ki hoy?
1758.
495 to ki hoy?
495 condonation.
ঠিক আছে, রাখা। ঠিক আছে। Your name?
M Bhattacharya.
By next to ঠিক করে থয়, ইয়ার যেটা বেলেগ চলে থয়। Heard MS M Bhattacharya, Learned Counsel, appearing for the applicant. The instant application is being filed to withdraw the condonation application. Being IA civil number 495 of 2024 filed for condoning 8 days delay in preferring the accompanying civil revision being serial number 1758, right?
Yes.
1758 of 2024, and also civil revision IO number 12933 of 2023. It is submitted that the parties have amicably entered into settlement of the disputes, and accordingly joint petition has been filed before the additional district judge Dibrugarh, wherein the additional district judge by judgment and decree dated 25/3/2025 disposed of the title suit number within bracket D 30/2022 in terms of the compromise arrived between the parties. In view of the compromise arrived between the parties amicably, and in view of the endorsement made by the learned counsels appearing for the parties, the I stands allowed. Consequently, এইকেইটা withdraw বুলি কৈ দিবা তাৰ লগত থকা ISI. Next to this. Second to I317. ইয়াতো একে ধৰণৰে হ'ব। ইয়াত খালি বস্তুকেইটা অলপ ৰেফাৰেন্স বোৰ ইয়াত কষ্ট টাইটলত পাই যাবা। আৰু ডিলেটো কিমান দিন? ডিলে কন্ডোনেশনটো ক'ত গ'ল? 137 days. Hetu yate pai jaba. Order against the order 3623 passed in Ms. J case number 2922 arising out of title suit divorce 30 of 20. Reference to yat silent leho. Pariba na? Prayer to asa page 5 what? Tapra loloba. 768. 2024 revision petition serial number 1839 of 24 and connected civil revision IO number 12933 of 2023. Hmm? 35 to ki har karne. That very good. Condonation. Another one is the item 35.
Yes, Your Lord.
What is that?
35. 12933. Yes, Your Lordship, there are, order has been passed, Your Lordship, in 3623.
Where is it? Border correction. What is order? I can't find. Order passed where?
Order passed 3623 in CRP 12933. In miscase, in IA 3171.
I have it. The order says, however, she's yet nothing, no order is passed.
Yes, Your Lordship, IA 3171.
I have it 3171.
Yes, kindly produce 3623.
What order?
There,
No, yeah, order. You have a look at it. Huh? No, but this is not in the file. We'll call this.
in this case, it appears the condonation application has been preferred against the order of the two
Yes,
separate
ma'am.
case.
Miss Bhattacharya, be here at 1 o'clock. In the meantime, you examine this file. I don't see any order here. Rupak, silo etu ki. Baki kitat mara. Etu, তাৰপিছত মাতি নিলে। তেওঁলোকৰ দুটা matter আছিল তো 32 হৈ গ'ল 33 হৈ গ'ল what about 34
33 34 have been
34 and 35
okay so 35 to check কৰি ললে হয় কি অনুপম লাগিলে 35 to কাৰণে আহি যাবা এক মিনিট so join I think 35 Rupak is already mentioned in 33 prayer for withdrawal. Check korila confusion to dekhai check korila ki order koi ase. Yes.
I have withdrawn item number 35.
You have instructions to withdraw?
Yes, I hear 317.
Okay. MSM Bhattacharya, Learned Counsel appearing for the applicant, submits that she has received instructions not to press the instant interlocutory application filed for condoning the delay occurred in filing the connected civil revision petition in view of the compromise arrived between the parties amicably. In view of the aforesaid endorsement, the IA stands dismissed on being withdrawn. Yes, Mr. Datta, a little clarification is required that proviso talks of employer. Now, the applicant here is, appellant here is not an employer because he's the insurance company. He hasn't employed. Employer is defined.
Also, I'm ready to deposit 50%. Let's say leave the
employer is already defined.
Yes, yes.
Employer includes any body of persons, whether incorporated or not, and any managing agent of an employer and the legal representative of a deceased employer. And when the services of an employee are temporarily lent or let on fire to another person by the person so-and-so has entered into any contract of service of so-and-so.
Yes.
Now, the insurance company is not entering into any of these. He's not the agent of the company. He is an insurance company. He's a jurist, independent, juristic person. Yes.
My answer to that question is the moment it is insured, he takes all the
responsibility. Unless you have something to show, the employer doesn't come under this. So, etur he first order eta pronobe disle substantial question of frame ase hetu order thakibo aru stay subject to 50% etu add kori diba tat. Yes. I'm not leaving it open. When it comes, it will see. This doesn't arise. Employer, he's not an employer. Yes.
Otherwise, this beneficial provision.
Then, Lord, I will argue
50%.
If he insists on arguing on that part, that proviso,
question of
then
insisting is
next
not
date
a
maybe
question
I
of
will argue on that, Lord, I will satisfy Lord.
To me,
But
Pranabar that already ordered to us. So just get that order to me, Makoidim. All right, that we'll keep it on the same date. You satisfy.
Yes.
Then 50% will go right now.
I'm not saying anything right
yes,
now.
yes,
I'm not,
Lordship.
I have not framed the substantial, I have not admitted the appeal.
Lordship.
You want to address the court on the employer? Let Mr. Doctor
Yes.
try his, because prima
I'll
facie,
respond.
however, I'll record the prima facie satisfaction of the court.
Lordship.
Well, in that case, my lord, what I feel, let the client enjoy their at least 50% of the.
I am readily giving you that. 50%
He's
I'm
insisting
giving.
on 100% right now,
No,
and he's
say-
saying that
Mr. Barman, sorry, Mr.
There is
Datta.
some way.
Mr. Datta, I was almost admitting the appeal, framing the substantial question of law, and awarding subject, of course, stay subject, of course, to payment of deposit of 50%. If you are agreeable to that, that order can go. You are agreeable to that? Pranab koi di bahata.
Then appeal may be admitted, Lordship.
You don't want me to
Lordship,
repeat it,
yes,
Mr.
Lordship,
Barman?
one thing, subject to a bond, release of debt, no? Subject to a bond.
No, I'm not adding the subject of payment of 50%.
Lordship, then.
And once it is paid, it will be stayed. Otherwise, not. Yes.
Within a time frame,
I will be paid, paying within 2 weeks.
But no time frame.
Yes,
Whenever,
yes, no,
if they don't pay, they don't pay, Mr. Doctor. Once payment is made, it will get stayed.
I can assure.
It is for him.
I can assure.
then they will be hurried.
All right, next matter, please.
Oblige, Lordship.
Oblige.
Item 36.
So I is listening for the first step, condonation of delay of lordship,
How many?
647.
Notice has to go.
Yes.
Notice. Next.
Next also same lordship, here delay is of 646.
Notice. Notice.
38.
First time. First time.
Yes, Lord.
Notice. Condemnation ever, huh? Sir? Notice.
Lordship, respondent number 2 and 3 are the owner and drivers. They
But
are
notice has to go, no?
Lordship.
39.
19 days. First time. Notice. Otherwise, I could have just condoned it, but what to do? Notice.
Item 40.
190 days. Notice? Notice. 41 to there.
Item 42.
72 days. First time. Notice. Number
For hearing, item number 44.
Yeah, please, Lordship. My lord, the divorce petition was filed by the husband. And wife has objected and wife has filed this petition. But now it is learned that already the husband is living with another woman and has also paid a good amount, and he has also admitted that I have paid one woman of Kokrajhar more than 3 lakhs, 3,72,000. So otherwise the purpose of marriage is totally vitiated. Now the learned district judge has provided the one-time alimony of rupees 10 lakhs and 5,000 per month to the minor. Now, my lord, the husband is a military person.
Is that?
Military.
What post? Military what?
He said only military.
But what? He's a Jawan.
John.
He's a Jawan.
Now, my lord, my submission would be that some amount of increase in that rupees and 5,000 per month to the minor, one time that may be paid. Otherwise, every day I will knock his door. So in that view, the divorce may be allowed. Because purpose is totally vitiated.
No, you are not contesting right now the divorce decree granted by the family court on merit. You are only saying to enhance the permanent alimony.
Yes.
And the maintenance, monthly maintenance of the child.
Right.
Correct, Mr.
Yes,
Mahmood?
yes.
This is your. Yes, what
One
do you
time,
have?
One time that.
What is your reply to the said argument.
Here, the London district judge has categorically found, decided that what is the income, everything has been taken into account, and he is a Joan, and he is in church, is just going to be retired also. The 10 lakhs, this has been awarded by considering all the aspects.
Where do we get all
Judgment
that?
starts from page 67. Look. It starts from page 67. And
Page?
page 6 starts from page 67. 67. Look. And regarding income, that is at paragraph 18, page 79.
Page?
Page 79, paragraph 18. The issue regarding relief, it starts paragraph 16 of the same page. So far reliefs are concerned, in way of proving the ground, these all things. Paragraph 18, it is an admitted fact that the petitioner husband is serving in Indian Army, Assam Regiment, and he is getting a gross salary of rupees 55,068. The petitioner has denied the suggestion that he has, apart from his salary income, he earns rupees 60,000 per annum from cultivation and from fishery. He used to earn 70,000 to rupees 80,000 per annum. Taking the admitted salary income and after deducting the tax liability and other contextual liabilities, etc., and fluctuating nature of the income due to posting, the monthly income can safely be taken as rupees 50,000 at the minimum. Considering above income, I am of the opinion that it will be just and proper to direct the petitioner husband to pay rupees 10 lakhs as permanent alimony to the respondent.
Jawan, how can he give you more than 10 lakhs?
My lord, may kindly see page 73 for a moment.
73.
73, para 10.
So because these amounts ultimately has to be such that the person can also give. Now, unless we have something in front of us which suggests that the person has a higher income, it would be difficult, no?
It is higher income.
Because this is not a small amount.
After
10 lakhs is quite a huge amount.
Kindly see page 73.
73,
When he
yes.
can give another woman who is...
Read. Where?
In his cross-examination, the petitioner husband, as PW1, has denied the suggestion of making physical tortures on the respondent wife and that the allegations brought by him are false. He also denied having maintained illicit relation with one Bonasri Burman, now living at Bongaigaon. However, admitted that he has transferred rupees 3,72,000 to said Bonasri Burman.
But as loan.
But as loan. My lord, my submission is this. Will a person will pay a loan of rupees 3,72,000 to another woman and living his own?
We don't know all that.
It
We
is...
don't know that. He may have it. He may have a fixed deposit. Because of some personal relation with Banashri Burman, he may have given. We don't know.
But this very difficult to
No,
believe.
you see, we don't know that. Now, because he's given, because he is a sympathetic person, because he on humanitarian ground, if he has given someone a loan, would it be just for us to now fasten him with a liability which otherwise looks unreasonable on the face of what has come out as his income? Because on record it has come that his monthly income is 50,000, right? Around. The family code has taken it as around 50,000.
My lord, he has sympathy with Bonasri Burman, but has no sympathy
He's giving you 10 lakhs.
Wife.
He's giving you 10 lakhs. He's giving you 10 lakhs. He's giving you.
And this 5,000 every time I will.
Can that be done? One time, 5 lakh, 5,000?
One time,
at one go. What amount? What would be that amount?
Because the findings of the learned district judge is that 5,000. But had there been any findings that we have to any direction that in alternative we have to pay such, then it is different. But there is no such findings. And apart from it, the maintenance
there is, I have not found any provision to one-time maintenance to the minor side.
Because that may be
That is
fixed,
not, yeah.
even that may be fixed in the name of
Because
the
the
minor.
tomorrow minor may have some more expenditures requirement and then enhancement.
It's fair enough. You're getting 5,000.
Yes, my lord.
No, 5,000,
It is not,
we are not,
Mr. Mahmood, sorry.
no, what I think, my lord, if 5,000, I am not so much objecting.
10 lakhs.
But, my lord, 10 lakhs to wife, my lord, but 5 lakhs.
One time will be difficult, Mr. Mahmood. All right. Heard Mr. M.U. Mahmood, Learned Counsel, appearing for the appellant.
Regarding minor, my lord, some permanent.
Also heard Mr.
K.M. Haloy.
K.M.
Haloy.
M. Haloy, Learned Counsel, appearing for the respondent husband and petitioner wife. Appellant wife, respondent husband. The by filing the instant appeal under Section 28 of the Hindu Marriage Act 1955, the appellant wife is assailing the impugned judgment decree dated 21/3/2023 passed by the Learned District Judge Morigao in TSD case number 30 of 2020, whereby the divorce petition filed by the respondent husband was allowed. It is the specific, no, Mr. Robert. The brief facts of the case is that the respondent husband married the appellant on 28/8/2012 as per Hindu rites and customs and lived thereafter as husband and wife, as a result of which a female child was born who is aged about 8 years old, who is currently about 8 years old.
Currently from 2014, my lord. Currently it would be about
9 years.
11.
About 9 years. It is the specific case of the appellant that during the marriage time, the respondent husband misbehaved with her and let loose cruelty upon her both mentally and physically. And that he also kept illicit relationship with several women and even paid good amount to those women. And accordingly, she protested the same by filing 2 cases against the respondent husband. And since the respondent husband promised to keep her as well, she did not pursue the said cases. However, the respondent husband later on filed a divorce suit against the appellant before the district judge at Morigao, wherein the learned district judge was pleased to grant decree of divorce, aggrieved with permanent alimony of rupees 10 lakhs to the appellant wife and rupees 5,000 per month for the minor until further orders. Mr. Mahmood, Learned Counsel for the appellant, submits that the permanent alimony of rupees 10 lakhs awarded by the district court is not proportionate to the income of the husband respondent, and that instead of rupees 5,000 per month awarded for the minor be given as a one-time lump sum amount. Per contra, Mr. So-and-so, Learned Counsel for the respondent husband, submits that the learned district court, upon analyzing and examining the financial capacity of the respondent husband, having granted the permanent alimony of rupees 10 lakhs and 5,000 per month for the minor. No interference thereof is warranted. I have given my due consideration to the arguments advanced by the learned counsel appearing for the contending parties and have perused the materials available on record. It appears that the decree of divorce granted by the Court of the District Judge Morigao is not contested on merits. However, the award of 10 lakhs permanent alimony is being assailed however, enhancement of the 10 lakhs permanent alimony is sought. It is apparent that it is apparent from the material available on record that the respondent husband is serving in Indian Army within bracket Assam Regiment and is getting a gross salary of rupees 55,068 at the relevant time. Correct?
Right.
It is further apparent that the learned district court, taking the admitted salary income and after deducting the tax liability and other contractual liabilities, etc., and fluctuating nature of the income due to posting, rounded off the monthly income to rupees 50,000 at the minimum. It is further apparent that the learned district court, upon considering the income as rupees 50,000 per month, directed the respondent husband to pay rupees 10 lakhs as permanent alimony to the appellant wife under section 25 of the Hindu Marriage Act. It is apparent that the above amount is calculated on the basis of 20 times of his monthly income and also keeping in mind that he has to pay maintenance to his minor child presently living with the respondent. It is further
presently with appellant.
With the appellant, not the respondent. Presently living with the appellant.
Monthly maintenance, paragraph 21 it is discussed.
After considering the need of the minor vis-a-vis the paying capacity of the respondent husband, the respondent husband was directed to pay rupees 5,000 per month as maintenance under section 26 of the Hindu Marriage Act for the minor child. The above order appears to be reasonable in the facts and circumstances of the case. There appears, it is apparent, I am of the unhesitant view that the learned district court has not committed any illegality or infirmity in granting the decree of divorce and awarding the aforesaid sum of rupees and granting the permanent alimony as awarded. That being so, no interference is called for. Appeal stands dismissed. Sorry.
My lord, dismiss may bring some wrong interpretation. It may be disposed of in that view, sir.
Disposed of. Yes.
LCR may be returned, my lord. So that-
Return TCR.
In this 5,011 into the child, my lord, that should be regularly paid. That
So far, they have not defaulted. Yes, next. Complete.